International Court of Justice has agreed to extend the timeline in South Africa's genocide case against Israel, giving both sides significantly more time to essentially prepare their arguments before the court hears the merits of the case. I'm sure we all remember South Africa launched proceedings against Israel back in December 2023, if I'm not mistaken, alleging violations of the Genocide Convention. This was in relation to its military campaign in Gaza. Since then, the case has attracted global attention with several countries seeking to intervene. And the court, the International Court of Justice, also being very, very vocal when it comes to how they've been handling the case. And we're going to be unpacking those developments and trying to get the latest from them. And we'll be speaking with Advocate Aslam Bava, who'll be giving us more insight on this update and what it essentially means for South Africa and why is it going to take so much time. There's, I don't know, the case going to be heard again in 2027, if I'm not mistaken. And I think it's very, very important to unpack all of these developments and to help us understand the latest when it comes to the ICJ case, very, very unprecedented case that South Africa presented to the International Court. We're joined by Advocate Aslam Bava via our virtual platform. Advocate, thank you so much for joining us. Welcome to Salam Media. Welcome to News and Views. Really appreciate you giving us your time.
Thank you. Salam, hello, and salam to the listeners. Yes, it is an important development in terms of the fact that extensions have been sought and granted. Perhaps just to give a bit of a background, these extensions are only in respect of the written submissions, meaning the pleadings. And this is not the hearing. So the hearing could take place sometime in 2029 or 2030. What the court has granted is South Africa has sought an extension to file additional submissions, indicating that Israel has provided a defense, and that defense constitutes about 4,000 pages. So we need to understand, I think many people go through cases and understand a bit of the court processes. The court processes are broken into two primary aspects in this case, and generally as at trials. One is the stage where written submissions have to be made, and that is the basis on which the party makes out the case, and which the party informs the court and the opposite side that this is the case you have to meet, particularly to the opposite side, this is the case you have to meet. And then the opposite side then presents its defense and says, we disagree with you, and this is our defense, and they put that before court. So in this instance, what happened was that Israel was previously supposed to present the defense, which they ultimately did in March this year. Mm-hmm. They sought two extensions, and they were granted two extensions. The first request was made in April 2025, and they wanted an additional 5 months. There they stated that the evidentiary issues and unresolved, what they termed at that stage, they couldn't access some documents in the hyperlink. And that extension was then given to them until the 12th of January this year. Prior to the 12th of January, they then made, in October 2025, as they were going through, they made a second request. And that second request was given. They asked for 6-month extension. They asked for 5-month extension. They were granted a 2-month extension. And 12th of March 2026 was the second extension granted for them to file a defense. Remember, at this stage, we're talking about the fact that parties are putting the defenses before the court. It is also interesting to note that these defenses and all the pleadings as they were, the documents are confidential and they kept secret and they're not made public. Mm-hmm. until the stage when it's ready to go to trial, and that's a later stage. So currently, what has happened is South Africa requested the ICJ and said, we're faced with a number of documents, and we need to provide a response to this, a reply. And the reason for that is that you cannot come in and start presenting evidence if you do not set out the groundwork in your papers, because the opposite party can simply argue that this is not the case we were asked to meet, and therefore you cannot lead evidence to that effect, and that will cause another delay. So just to get the timelines right, South Africa's extension is now granted until the 22nd of November 2027, an 18-month extension. That is until next year, November, 22nd November 2027. And then Israel is granted an extension of an equal time until 22nd of November 2029. And this, South Africa has indicated, apart from the fact that the sheer volume of the documents that it needs to deal with and present that case on pleadings, it also indicates that the case has become complex. And here we will note that many countries have joined South Africa. I mean, it would be remiss of me not to indicate that South Africa taking Israel to the ICJ must stand in terms of our law, international law, as one of the highlights, where South Africa has taken upon itself to bring a perpetrator of oppression and of genocide to the highest court in the world. No other country was prepared to do it, but now we know that many countries have joined. We've got numerous countries, Ireland, amongst others. So yeah, as it now goes through, it's one would have wished. You look on TV and you say, but it's so plain. It's anybody can see it. It's happening right in front, and that's true. But in a court, the court can't say, okay, I've seen this on TV, so therefore I come to the conclusion. It has to say, what is the evidence presented before the court? And so, prior to this, there were 3 interim orders that were granted in favor of South Africa. And that was, we know the first one was the 26th of January, 2024. And thereafter, Israel refused, as it continues to refuse, and it's just a rogue state. It then refused, and there was a modification brought on 16 February 2024, again an interim order. And what is an interim order? It's not a final order. It's to assist a party in the interim pending the final determination of the case. And then the third was the humanitarian and famine order. And here you recall that food was stopped, water was stopped, open land crossings were then basically an imprisonment. And then again, there was in May 2024, there was the Rafah offensive order. So South Africa has been continuously going to the court, asking for changes or additions to the interim order, because Israel is just a serial violator. It has never, ever complied with international law. It sees itself as an exceptional entity, obviously a superior racist entity. But what is very important to note as well is that this case, although it's taking long, it has put some sort of pressure on Israel, a tremendous sort of pressure, and that is why you're getting various countries, the UK, the United States, seeking to put pressure on South Africa to drop this case, because it's an embarrassment. I mean, this is a criminal and a rogue state, and it's as any criminal wouldn't want the case to go to court. We've seen various instances just in our local law and cases that criminals generally, the issue is to try and defer it and to postpone it. Um, and the fact that Israel is now caught up with the situation, it is now trying to weasel itself out, trying to put political pressure through various means. And we know that there is a coalition of these forces trying to derail this entire case brought by South Africa.
I think what was interesting for me is the timelines that are given here. Is it something that is normal in international law, and the cases to have this long amount of time? Because I think when this case was presented, a lot of South Africans just thought, in the next couple of months we'll be seeing judgments, and what we all know would at this time probably be proven by the South African legal team and the ICJ would have made a judgment by now. But then we're talking years. Is this normal procedure, especially in international law cases?
Yeah, so we've got one precedent on this, at least. That's the Bosnian case, and that took a while for the case to finalize. In this case, what has happened is that apart from what I indicated was the additional documentation and the complexity of the case, the other point that Israel has raised is the jurisdiction. It says the ICJ has no jurisdiction in this particular matter. So yes, answering the question, these cases do take a while. They and this particular request of 18 months was a request made by South Africa. So it could have, obviously the legal teams would have looked at the documents and would have worked out the timeline they needed in order to file a proper and comprehensive response to what Israel is saying. And then Israel, obviously the ICJ said that if South Africa is given this opportunity, we want to afford Israel the opportunity of filing a further set of documents as well. And that is perhaps one of the reasons for the delay. And I have no doubt that Israel has introduced all of these elements. From what you're raising, it's very important. I mean, we always say justice delayed is justice denied. So in this particular case, it is a rather huge and complex case in terms of presenting the proper evidence, because the other alternative is to simply say, okay, we've got sufficient pleadings and evidence before the court, let us go through and have the matter argued. But it's far too important a case, because if the ICJ rules and says Israel is, or there's insufficient evidence presented to the court, and the pleadings do not justify that a genocide is being committed, which we all can see is being committed, but this ruling then has effects on states and states who participate and who are signatories to the Genocide Convention.
And how difficult is it to prove genocidal intent, and why is that likely to be a very, very important and key battleground in this case?
Yeah, so the genocidal intent is quite a difficult aspect to prove. To understand, the two basic elements that have to be proven is by South Africa and the other countries that have now joined the case, is the mental element, or mens rea, and then the physical element, or the actus reus. Now, in this is the mental element is a particularly difficult element to prove. It needs to prove that the intention was first. We know it's broken into like three different elements, and the intent by Israel must be to destroy in whole or in part a national, ethnical, racial, or religious group. So not just that we see it happening in real time as we have, but they have to. The mental element has to be proved, that they actually have an intention to do so, and this one picks up from statements that were made and are continuously made, and the acts that are committed. Then the distinction is also the group must be targeted simply because of their identity as members of the group, rather than for military or strategic reasons. So far, it appears that Israel's continuous argument is that they're going after so-called terrorists. By the way, I would just ask the listeners and the viewers to go to Edward Said in his writings, and he indicated that he would never refer to the Palestinians struggling for freedom as terrorists. So that is a very important thing. They are freedom fighters. And then proving intent. So because in this case, we see so much of the social media, which will be helpful to South Africa, but that element has to be proven. And then after that goes to the physical element, and it's broken down into just 4 elements I want to put. Killing the members of a protected group, causing serious bodily or mental harm, deliberately inflicting conditions of life calculated to bring about the group's destruction, imposing measures intended to prevent births within a group, and forcibly transferring children of the group to another group. So these are physical elements. So those 2 aspects, as you are hearing now, require an immense amount of and thorough preparation as to how South Africa is then going to prove this case against Israel, which to us as observers, we can clearly see this happening, but the court has to be convinced.
There we go, Advocate Aslam Bava. I think we're going to need to have a part 2 of this conversation, considering the fact that there's still so much to unpack. I think when this case was first presented to the ICJ, there was a lot of excitement. People, thought finally we're going to see a time where Israel is held accountable for their actions in Palestine. But I think there's multi-layered kind of aspects to it that we all need to understand a bit more, and that we all need to read about and learn about. And I think you can be the person that can assist us with that. And I'll talk to my producer. We definitely need to chat again. Thank you so much for joining us. Going to leave it here for now.
Thank you. It was good being with you.
There you go, Advocate Aslam Bava, giving us insight on the ICJ case, which remains one of the most closely watched legal proceedings in the world, not only because of its implications for Israel and Palestine, but I think also because of the questions it raises about accountability, about international humanitarian law, and just the general future interpretation of the Genocide Convention and the trust in institutions like the International Court, like the United Nations. So, as I mentioned, we're going to need part 2 of this conversation, and we really appreciate his analysis, and look forward to speaking to him again. We're going to take a quick break. News and views will continue after this.